Welcome to Armor and Advocacy.
Welcome to Armor and Advocacy with Colin McNamee of McNamee Defense. Colin is an Ohio criminal defense attorney known for discreet, strategic representation in high-stakes criminal cases. His work focuses on protecting clients' rights, reputation, career, family, and future while avoiding unnecessary public exposure whenever possible. I'm Lisa Mosbey, and today we're looking at how criminal cases are resolved without going to trial and the strategy behind those outcomes. Welcome, Colin. Thank you so much for joining me today.
Thank you so much for having me, Lisa. I really appreciate it.
You know, Colin, a lot of people picture criminal defense as a courtroom fight, but most cases never go to trial. How do you usually explain that reality to someone who's scared about what comes next?
Trial is high stakes, Lisa. You're absolutely right about that. It's a nerve-wracking and anxiety-causing process for anyone, but particularly for those amongst us who do not have the experience and who, for instance, are not lawyers. Lawyers thrive on trial. It's what we were trained for, and it's what we look forward to in defending these cases. However, oftentimes, probably more often than not, trial is not in the client's best interest. We try to bargain for certainty. So we use a combination of diplomacy, negotiation, leverage, investigation, and personality to try and accomplish a client's goal of creating a certain or as certain as possible outcome to a criminal matter.
And Colin, what are the main ways that a criminal case can be resolved before trial? And how are those options different from simply taking a plea?
So in Ohio, Lisa, we have many different devices in the law that are baked in options short of going to trial that are not taking a plea or accepting a plea offer, as some people might put it. There's a device in the law called intervention in lieu of conviction or treatment in lieu of conviction. And for persons who struggle with mental health concerns or substance use, there are ways that we can force the court and the prosecution to go down the route of a pretrial probation, where the defendant, in this case my client, would otherwise engage in counseling, treatment, in or outpatient for a period of 12 or so months, and on successful completion of that program, the case is dismissed and the records are expunged forever. And that's a statutory device that when an application is made and the court accepts it, it overrides the prosecution's desire to prosecute or punish, where in this aspect of the law favors rehabilitation without actually proceeding all the way through the criminal process. We also have diversion, which is another form of pretrial probation. That is a prosecution-controlled device that is creation of statute. The prosecutor decides who enters into and who does not enter into diversion. And once the specific conditions of the prosecutor's diversion program are met, often the case is thereafter dismissed and the records of it expunged forever. We also have community service or other sort of deferred prosecution, where we put the case on hold or continue it for a couple months and allow the client or the defendant to complete certain criminal adjacent punishments, not really probation, but maybe they would attend counseling, perform community service hours, indicate to the court and the prosecutor that they're able and willing to conform their conduct to the law and demonstrate that it truly was a mistake that they made, and that through service and good behavior prior to the commencement of or the closure of a prosecution, that they're able to work through a sort of informal program to close out the case. Also, again, just through diligent investigation of the cases, pointing out to the prosecutor the deficiencies in their evidence before we ever get toward the end of the process, which is trial, showing the prosecutor that they're not able to meet their burden to prove my client guilty beyond a reasonable doubt, often ends in a dismissal or a reduction of the charges. And a reduction is the certainty for which clients are often bargaining, Lisa. Thank you. That's a good question.
And it's a great answer. And it's surprising to a layperson like myself that there are so many options available. But I'm curious, what needs to happen early in a case to create the possibility of a quieter, more controlled resolution?
Please, 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 everyone that is out there listening, talk to a qualified criminal defense attorney as soon as possible. We as good citizens and people who paid attention in school, had good parents, all of that, we're trained as young people to cooperate, to submit to authority, to answer questions. That is often against your best wishes, and you have the right to remain silent. Exercise it. Police officers, law enforcement agencies, regulatory agencies, prosecutors, they will not be offended if you tell them, gosh, I'd really like to answer your question, but first I'm going to talk to my lawyer. Call a qualified criminal defense lawyer immediately, preferably myself at McNamee Defense, but obviously if you all have other family connections, referral sources, please talk to a qualified criminal defense lawyer before you ever engage with the government, before you ever talk to the police, certainly before you answer any questions that are relevant, even if you think they are not relevant to your case. If they seem mundane, if they don't seem all that detailed, the police and law enforcement have designs in their questions. They almost always know or think that they know the answer to a question before it's asked. Do not give them an answer. The best thing that you can do to control the outcome and shape it toward a positive outcome is to talk to a lawyer early, often, and have that lawyer confront law enforcement and answer any questions on your behalf.
Colin, how do you evaluate whether the evidence gives you leverage in negotiations or points toward a more aggressive defense?
We have a lot of experience here in my office, Lisa, and we take a focused look at each and every case on an individual basis. Now, that's the nuances of the facts. What is there? Importantly, what is not there? What are the witnesses saying? What could a witness have seen? What might not have been possible for a witness to perceive? We assess the individual client, their situation, their needs, and take a personalized approach to every single case. All facts are different. No situation is the same. And no matter how many times I've worked through a given case, whether it's domestic violence, DUI or OVI, menacing, a gun charge, a drug possession charge, there's always something, some little fact or the absence of some little fact or bit of evidence on which the case could possibly turn. And we dig in deep and early to make sure that we have our best opportunity to uncover those strengths for the client, weaknesses or deficiencies in the prosecution's case, to try and work the best possible outcome. Again, Lisa, the goal is certainty. Nothing in life is certain, of course. Nobody and nothing is perfect. But if we can work to shape an outcome toward a desired result, that control and that element of knowing what comes next is often very, very important for achieving a positive result.
And Colin, taking into account all the nuances of each case, the customization, the conversations that you have with your clients, what kinds of long-term consequences are you thinking about beyond the immediate charge itself?
Lawyers call those secondary consequences collateral consequences. Oftentimes you'll hear that or you'll see that out there on somebody's website for those folks who are listening. Anything that is not directly related to punishment can be a collateral consequence. Think employment. If you have even the simplest or most mundane of convictions on your record, a prospective employer might choose to hire someone else over you. They might put your resume in the bottom of the stack. Even if this occurrence in your life happened many, many years ago, you might still be judged or passed over for employment, for promotions. School. Oftentimes, certain criminal convictions make folks ineligible for student aid. They make folks ineligible, especially young people, to live in college dormitories on campus, to join and be part of certain campus groups. Another obvious one, Lisa, is fundamental rights. Think the Second Amendment, your right to vote. Persons convicted of most felony offenses lose their right to vote, perhaps forever. You lose your right to keep and bear arms, to defend yourself, a fundamental American freedom. You lose your right to hold public office, to hold potential professional licenses, like to become a nurse, a barber of all things, a lawyer, a doctor. Convictions for certain offenses bar you forever from obtaining and holding those licenses. Housing. For those of us who are just starting out in life and are renting apartments, certain types of convictions, even for misdemeanors, will cause a leasing office to deny us the opportunity to live on their property. Insurance, life insurance in particular, but car insurance is something that folks are familiar with. Persons with certain types of convictions can be rated higher for life insurance for the rest of their lives, seen as higher risk for having been convicted of a criminal offense. Then you have, the other sort of social consequences, Lisa, like community judgment, right? We all try very hard not to judge one another, but after all, we're human. So especially with the advent of the internet and all of these easily accessible and sometimes free background check websites, your neighbors, friends, love interests, family members, if they're nosy, might choose to look us up and judge us based upon what they think they now know about us from our criminal history.
And that's such a long list. We can't even travel to certain countries if there's a felony involved. So, quiet resolution can sound simple from the outside, but what makes it so difficult to achieve in practice?
And that's an excellent point that you made there, following up, Lisa. Canada, for instance, here we are in Ohio. It's very easy to drive to Windsor, to fly to Toronto. You make an excellent point. Those of us, say, for instance, a person convicted of domestic violence or a misdemeanor menacing or assault charge might well be denied entry to Canada at the border. And that comes as a surprise to many. You might well be on a family or work trip and you present your passport to the border control officer as you're coming through the airport or through a port of entry in an automobile, and you can be turned away at the border based upon a background check that authorities would run upon your desire or request to be admitted to Canada. That's an excellent point, Lisa. Thank you for bringing that up. A quiet resolution,
Yeah.
that it really requires reputation, first and foremost, I think, to back up the threat and the specter of going to trial. If I bring to the prosecutor what I think is an aspect of their case, which means they'll have a hard time securing a conviction, they have a weak case, the prosecutor, knowing that I have the reputation to take a case to trial, that I'm willing to advise my client, to select a jury, to sit down, to dedicate the time, to take the chance, to test the evidence and force the prosecution to prove my client beyond a reasonable doubt, because of course we're all innocent until proven guilty, Lisa. And having the reputation that the prosecutors know and the judges respect how my firm conducts trials goes a long way in ensuring that what we say in those conference rooms during the pretrial negotiation phase of a case carries a lot of weight. We want to make sure that everyone knows that we are serious and formidable when it comes to taking these matters to trial. Yes, a lot of cases, most cases, in fact, are resolved by way of a plea agreement. But when it really counts, and when the facts are in question, and when reputations and livelihoods are at stake, trial is often the only possible outcome if we cannot otherwise convince the prosecution to drop the case. Getting out in front of something immediately goes back to what we talked about earlier, Lisa, where we want to make sure that prospective clients are talking to a criminal defense lawyer immediately. We want to be able to get out in front of the issue, to perhaps collect evidence on our own, to subpoena video footage, to get call records, to talk to witnesses maybe before they've had the chance to talk to law enforcement, so we can get that story first and that we can understand what the facts are and sometimes bring those facts to the prosecutor instead of being blindsided later on in the process. Having knowledge of the system and the persons involved having personal connections with the prosecutors, having dealt with them over a long career in criminal defense and focusing my practice, Lisa, on criminal defense, really ensures that the other side knows that we have a reputation for being serious, that what we say matters, that what comes out of my mouth is true and not hyperbole or conjecture, and that knowing those persons and having the ability to reach out to them directly by and through those personal connections really, really counts when it matters most.
I know your reputation and how you treat your clients is of utmost value and importance to you and all of your team. Can you share an example with us about like identifying details of a case where preparation helped to resolve the matter quietly and avoided unnecessary exposure to your client?
Much like other skilled and experienced criminal defense lawyers, Lisa, I enjoy nerding out on the scientific aspects in particular of criminal cases. Think drug chemistry, for instance, being able to read gas chromatography, mass spectrometry type reports and understand what the peaks and valleys on those particular graphs mean in a case where, for instance, my client's accused of drugged driving and unfortunately is involved in an accident where a person is seriously injured or loses their life. Understanding those analytical reports, being able to digest them on my own and quickly without retaining an expert or knowing when to bring on an expert, perhaps even more importantly, has led to a lot of positive results and to speed along the process to get a case over and done with sooner rather than later to minimize the publicity. And the same goes for delving into DNA analysis and the science behind it. Pressing the prosecutor without the need for trial and cross-examination of a government expert before it even goes that far, outlining to the prosecutor, this is where I think you, government, are going to have trouble proving your case. You ought to think about a different kind of resolution short of trial. Maybe you should make my client one of those offers that he or she cannot refuse. And this is why. And having that experience, having conducted those trials, having represented people in serious cases like murder, rape, and other types of sexual assault, I have a great deal of experience reading and digesting those reports and quickly putting them to use for my client's advantage.
Colin, thank you so much for your time today. And we really appreciate you shining a light on the details of this today and giving us the guidance from your experience.
Thank you for your excellent questions, Lisa. I very much appreciate it. I hope that my responses have been helpful to the audience, and I look forward to sharing another episode with them. Thank you.
That's it for today's episode of Armor and Advocacy. If you're facing a criminal charge or believe you may be under investigation in Ohio, early stages matter. To learn more or schedule a confidential consultation with Colin McNamee, visit McNameeDefense.com or call 614-957-7629. Thanks for listening, and don't forget to subscribe, share, and leave a review.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.